Good morning, everyone.
Good morning.
Good morning. Welcome to the inaugural meeting of the Maryland Joint Enforcement Task Force on Workplace Fraud. I'm Portia Wu, Secretary of the Maryland Department of Labor, and it is my honor to be here today to open us up, and I'm serving as Task Force Chair. So this task force was reestablished by Governor Moore through an executive order signed in January. We're honored to have the governor today here to kick us off. But before we get started, I do want to address why we're here bringing together leaders from across Maryland government to talk about workplace fraud. Workplace fraud, also known as worker misclassification, occurs when workers are misclassified improperly as independent contractors or paid under the table. And that means a whole host of legal protections and obligations and requirements are basically thrown out the window. Misclassification is unfair and inequitable. It makes Maryland less competitive, impacts our economic growth, and deprives our state of millions of dollars in lost revenue and resources. Frankly, it hurts all of us, but it particularly hurts low-wage workers, workers of color, immigrants, and other vulnerable populations, people who are economically on the brink and reluctant or maybe unable to speak up for themselves. This table today is a place for discussion, of course, but also for action. That's why we've convened this table of great thinkers, but really of doers. Each one of the members of the task force plays an important role in identifying cases of workplace fraud and helping to deter it. As underscored in the governor's executive order, a primary goal of the task force is to better inform and educate businesses and workers about the law, to coordinate information sharing, investigations, and referrals, and to strengthen compliance and enforcement. I can think of no one who is more ready to take action than the person who set this task force in motion, our doer-in-chief, Governor Wes Moore. Governor, thank you for being here this morning.
Thank you so much.
Thank you so much, and good morning. Good morning, and also thank you in advance. Thank you in advance because as one thing that we know is that the work of this task force, the work that you all have signed up to do, this is anything but ceremonial. This is going to be hard work. It's long overdue work. It's addressing something that has been significantly impacting so many of our communities and frankly discouraging people from raising their hands and saying yes to serve. And I'm so thankful for our not only secretary but also chair, Chair Wu, for taking on now an additional hat that she's going to take on, our Attorney General Anthony Brown, our Comptroller Brooke Learman, and each and every one of you. This really means a lot because this is a room of some of the busiest people that I know. People who do not have a minute to spare when it comes to their schedules, but you have figured out a way to carve out time to be able to address something that is incredibly important to every single Marylander. And I want to say thank you because, again, it's one thing I learned. If you want something actually done, find the busiest people you know. Ask them to do it. And you all have raised your hand to encourage other people to raise theirs. Because if we are going to encourage people to stand up and serve, if we're going to encourage people to be able to give of themselves and do work that is necessary, required, and immediate, the best way to recruit is making sure you're focusing on retention. One of the best ways you can focus on retention is by making sure that people who are in spots are actually being rewarded and acknowledged and paid for the work that they are doing. And it's time that Maryland get this right. You all are going to help us do exactly that. To win this decade, it means Maryland has to be a state that stands up for its workers, consistently and unapologetically. To win this decade, it means Maryland must be a state that stands for good pay, fair wages, and strong benefits. To win this decade, it means we need to be a state that stands up to bad actors who abuse and manipulate the system and let them know that those days are done. When we talk about workplace fraud, it does not just hurt individuals. Our chair said it best. It hurts all of us. It hurts every single one of us. It hurts our entrepreneurs because it's hard to keep pace with competitors when your competitors are cheating. It hurts the state because workplace fraud often involves serious tax evasion and allows people to skirt around the rules. It hurts our economy because bad actors target communities of color, and if the racial wealth gap continues to grow in our state, it means our fiscal health will continue to weaken. This is how we can use transparency to level a playing field. And this is our chance to build a fair and a competitive economy, and one where we don't have to choose, where we know that we can make sure that our businesses have opportunities to grow, but it will not be done on the backs and by the manipulation of our workers. So if you're working hard to bring money to support yourself and your family, we want to let you know that this is the task force, this is the group that's going to help make sure that you are seen and supported. And also, we are going to be very clear that if you try to exploit Maryland workers, we will hold you accountable. So I know we have a lot of work to do, and I know that I'm standing in the way between you all doing the work. But I want to once again just say thank you. Thank you for raising your hands to say yes. Thank you for making time in a schedule where none of you have the time, but doing it because you know this is going to benefit so many Marylanders who need and deserve a champion, and you all are those champions. So thank you so much. Proud to work with you and grateful for your service to leave no one behind. Bless you guys and thank you.
I hereby call the first 2024 Joint Employment Task Force meeting to order, and I'm honored to turn it over to our acting counsel with some remarks.
Oh, great, thank you. Thank you, Madam Chair, and a huge thank you to your team, Deb, Key, Deja, and everybody for pulling us together. Thanks to everybody for taking the time, and I'm really excited to serve with you all. And good morning. So last weekend, I was grocery shopping, and in the bakery section, someone yelled my name. I turned around and saw a face that I hadn't seen in years. One of my very first clients as an attorney when I was in Baltimore. He hadn't aged, and I was genuinely excited to see him. He gave me a hug and we chatted for a while. Since I'd represented him, he'd gone to get married, he had a cat, he was working baking goods and making prepared foods, using the skills that he'd learned at the restaurant where he worked when I'd represented him and all of his coworkers after they'd been laid off in violation of the Federal WARN Act. That case really changed my life. I saw up close the devastating effect that an employer's malfeasance can have on its employees. It was not a misclassification case, but it was a case where working men and women who had no bargaining power and were at the mercy of their employer got screwed. That's a technical term. And it was wrong. It hurt them, their families, and their friends. Throughout my career as an attorney, I was constantly amazed by the brave men and women who stepped up and sought out legal help to hold their employers accountable for their employers' unscrupulous methods. When their employers misclassified workers, when employers violate basic wage and hour laws, they are cheaters. They, number one, rob hardworking Marylanders under the benefits and protections they deserve and are guaranteed under the law. They, number two, pass the cost of their actions to Maryland taxpayers and businesses by stealing resources from the state. And three, they put law-abiding businesses at an unfair disadvantage, people who are doing the right thing. And so I want to thank Governor Moore and Secretary Wu and the team here today for pulling us together to start this joint enforcement task force. Proactively tackling this issue allows us to collect necessary revenue to help close the state's tax gap in order to reinvest in our people, our businesses that will make our economy even stronger. And the work of this task force and our respective agencies will set us on the right course, shining a spotlight on scofflaws and putting measures in place that will stop this egregious theft. Now, when you think about the impact of misclassification, it's pretty obvious. If you get paid regularly as an employee and you look at your pay stub, you see a number of taxes deducted from what you earned during the pay period, including state and local taxes. If you're classified as a contractor, that of course is not the case. And the impact of this misclassification is far-reaching. Misclassified workers make significantly less than workers paid as employees. They are denied minimum wage and overtime that they'd otherwise be entitled to. And when they're misclassified, they're robbed of their basic labor rights, their worker protections, including their right to collective bargaining, healthcare, and other key protections. For example, individuals classified as independent contractors are responsible for paying employment-based taxes that go towards Social Security and Medicare. The IRS estimates this to be about roughly 15% of earnings. Unethical employers engaging in worker misclassification and theft are literally passing their costs to workers, reducing their take-home pay. Worker misclassification and the theft that comes along with it stands to hurt, and really does hurt already, the already vulnerable members of our society. Many of those exploited by these predatory practices include people of color, immigrants, and people living paycheck to paycheck, who are living on the fringes, who may not know their rights or feel empowered to speak up themselves. And further, misclassification of workers hurts good corporate citizens, passing along a great financial burden to employers who are following the letter and the spirit of the law, as well as hurting Maryland taxpayers. National studies show that at least 10 to 30% of employers misclassify their employees as independent contractors. This theft really results in millions of dollars in lost assets, including lost income, tax revenues, state workers' comp, and unemployment insurance. I'm excited that this task force will enhance the information sharing across our state agencies and our ability to identify and target cases of business fraud and tax evasion. The compliance division of my agency will be able to go after unscrupulous employers by conducting targeted audits and leveraging appropriate penalties that will help make the state and other victims of this criminal practice whole. I'm so excited to welcome on my team, Maria Robolino, our Deputy Comptroller, and Matt Bowman, one of the chief auditors in our field audit, one of the managers in our field audit division. I'm honored to join Attorney General, Secretary Wu, all of you, and all of our friends in labor here today. And I look forward to partnering to ensure our state is rewarding law-abiding employers and protecting workers. Thank you.
Thank you, Madam Comptroller. General Bell, would you welcome some remarks from you?
Sure. Thank you, Madam Chair, Secretary Wu. I'll be brief in my remarks. I'm looking forward to hearing from our labor leaders and participating in the conversation and discussion with each and every one of you. I do want to thank Governor Moore for his commitment to addressing workplace fraud. It's long overdue, 8 years, and actually 8 years overdue. So I thank him for issuing this executive order, convening us so that we can begin to put all of the oars in the water at the same time, coordinating our efforts, maximizing our impact on behalf of workers in Maryland. Secretary Wu, thank you for your leadership, not only of this task force, but at the Department of Labor and you and your team there. I want to thank the Comptroller for your leadership as well. Two of my very best clients. So thank you for your privilege that we have to represent you and your organization. I want to thank the task force members. Also, let me acknowledge a few members of the Office of the Attorney General, Jennifer Baker and Sarah Harlan, who are here around the table, who are Assistant Attorneys General at the Department of Labor. Thank you for your commitment to serve. I also want to recognize one of my Deputy Attorneys General, Leonard Howey, who will be my designee when I'm not present at the task force meetings, which I don't think is going to happen that often. So Leonard, you're welcome to join me anytime we're here at the meeting. But Leonard brings extraordinary experience and talent, having once served as the Secretary of Labor and also as principal counsel to the department. We're here today, as the governor said, Secretary Wu has said, the comptroller said, regarding an issue that affects all of us. And we're here to convey a message that workforce fraud, particularly wage theft and misclassification, will not be tolerated in Maryland. As Maryland's chief legal officer, it is my duty to uphold justice, equity, and the rule of law, and that holds true in the marketplace and the workplace as much as it does in our civil, criminal, and administrative systems of justice. Workplace fraud, as we've heard, affects the entire community. We not only heard it, we experience it, we see it every day. It affects workers' dignity, their health, their financial well-being, our state's economy, and local and state government revenues when employers do not pay taxes. And wage theft disproportionately affects lower wage workers, women, people of color, and immigrant workers, and negatively affects local economies and tax revenues. Wage theft isn't limited to the construction and hospitality industry. We see it in the gig economy, we see it in retail services, we see it among large employers and small employers. Everyone you see here today is dedicated to ensuring that workplace fraud complaints are taken seriously, investigated, resolved quickly, and when necessary, prosecuted. My office responds to and takes seriously workplace fraud complaints that are brought to our attention. My assistant attorneys general, advise counsel, and represent the Division of Labor and Industry at the Department of Labor, including the Worker Classification Program Unit. Within my office at 200 St. Paul Place, there's also 3 divisions that are equipped to investigate workplace fraud, depending on the nature of the complaint. The newly created Civil Rights Division, the False Claims Unit within our Consumer Protection Division, and our Criminal Division's Fraud and Corruption Unit. And next week, I'm pleased to announce that we are going to be posting 2 positions, one for an attorney and one for an investigator, to form a workplace fraud tiger team in the Office of the Attorney General. And that tiger team will work across the Office of the Attorney General and across state government, and certainly relying in large part on the work of this task force to step up our game in the Office of the Attorney General on behalf of workers. My office looks forward to working with the task force. The task force will be an important asset for referral, coordination, and developing policy among agency partners, as well as a vehicle for raising awareness and preventing workplace fraud, and ultimately eliminating the illegal practices of misclassification and wage theft in our state. So thank you again, Madam Chair, for giving me an opportunity to share some thoughts and observations. I look forward to hearing from others and working with each and every one of you.
Thank you so much. So now we're going to dive in. I'll just sort of give a quick run of show. You all should have agendas in front of you, but just to give a sense of how this is going to unfold today, we're going to have some data and information presented by the Public Justice Center. We're going to hear from a number of key stakeholders, and that's going to lead into an interagency task force discussion. Before we do that, I just wanted to take a minute as chair to focus on the task force's mission and some initial thoughts I have about how we can prioritize over the course of this year. As outlined in the governor's executive order, the task force is forming goals. First, to understand the scope of workplace fraud in Maryland, the industries in which it's most prevalent, and its economic impact on businesses, workers, and the state. To work together as a government to share information more effectively and efficiently to target possible cases of workplace fraud, coordinate investigations between agencies, and better collaborate to enforce the law and hold those who evade it to account. To make recommendations both within the administration, including our independent agencies, and also to the General Assembly regarding how regulations and statutes can be strengthened to deter workplace fraud, and to promote outreach and better educate businesses and workers at federal and state employment and tax laws, and on how workplace fraud can create unfair marketplaces and make Maryland less competitive, as well as to educate people about workers' rights under the law and the impacts on health and safety under the working conditions. So to do this, enter this discussion today, we're going to start with some information about the prevalence and impact of workplace fraud in Maryland. I do want to say, I think this is an area the task force can focus on. It's difficult to quantify often, but it's something we'd like to continue to explore. We've been talking with some researchers. We welcome the thoughts of folks in the room today or who are watching online as to how we can best quantify and understand the impacts, understand the industries where we are seeing this phenomenon most often. I know that there was an analysis in one of our neighboring jurisdictions, Washington, D.C., that found that in one industry, misclassification was basically leading to cut corners to the tune of 17%, right? That's a huge impact across not only state programs, but also in workers' pocketbooks. So that's something we really need to look at and understand more deeply. Of course, something we're going to work on here is the information sharing. You know, that over the years, technology should be our friend. There's a lot we know now, a lot more data we're able to gather within our internal agencies and programs. But sometimes we face challenges understanding how can we best share that. Maybe there will need to be memorandums of understanding. Maybe there are updated portals or websites where not only we can take incoming questions and complaints or concerns, but also share among agencies. And I think that's a major goal that we all want to work toward. And I know there will be a lot of staff work trying to understand how we can fit those puzzle pieces together. And of course, education and outreach. We will be working to help everyone across Maryland better understand the law. Our laws are always changing. New industries are always coming online, new business models. We need to make sure everyone has an understanding of how our laws apply to them and what they can do either on the worker or business side to ensure that they are following the law. So we're going to discuss how we can coordinate some strategic outreach initiatives. We want to focus on small businesses. We want to get out into our communities, convene meetings in different parts of the state, work with our elected representatives at the state and local level to make sure they're brought into that conversation. So looking forward to that, and of course welcome ongoing feedback and ideas from the task force members as well as our stakeholders about how we can be using our time efficiently and effectively. I'd like to start our conversation today with the scope of workplace fraud, and I'm going to turn it over to Lucy, Joe, and David Robin from the Public Justice. Thank you.
Thank you so much, Secretary Wu, and
Madam Chair, if I may, and I apologize, I see on the agenda there is a roll call.
I forgot.
It may be helpful to have folks introduce themselves.
Yes, I apologize. I'm off script. Yes, correct. Are you going to manage what the foundation is, right? Right.
Staff will call the roll. Alrighty, good morning, everyone. Thank you. If everyone could just signify their presence by simply saying here. Chair Wu?
Here.
A.P. Burke?
Here.
Tom Dove?
Here.
Margaret Rexus, also known as Meg. Thank you. Comptroller Learman?
Here.
Attorney General Brown?
Here.
Maureen Quinn?
Here.
Kathleen Moraine?
Here.
Jonathan Glazer?
Here.
Thank you so much, and we have full attendance.
Okay. Okay. Sorry, going out of order. I do want to also say, if I didn't already, a special thank you to the staff who put all of this together, both the team at the Department of Labor and of course the governor's team for hosting us here today. I won't name everyone, there's a lot of folks here, but and I also want to note that Deja Desiree in particular is going to be helping guide us through this meeting today, as well as Ashley Sharper, Deputy Chief of Staff. And again, another thank you to our AAGs who are supporting the task force.
Madam Chair, one other interruption. I should point out that Ashley Sharp got an early start in her professional career in the district office of former Congressman Anthony Brown.
No wonder she's so outstanding. All right, we'll turn to our presenters. Thank you.
thank you so much, Secretary Wu. And my name is David Rodwin. I'm the lead attorney of the Workplace Justice Project at the Public Justice Center, and I'm here with my colleague Lucy Zhou. Much of our work has already been done by the outstanding framing of this issue and its consequences for workers, law-abiding businesses, and the state of Maryland by those who have already spoken. So what we will do is try to flesh that out a little bit and provide some data and information about how this issue manifests in nationwide and in Maryland specifically. So there we are. There's a number of different laws in Maryland that apply specifically to employees and not to independent contractors. Those laws define employee differently, and the legal tests to determine whether a worker is an employee or independent contractor can vary. And I don't want to get too far into the weeds on that, but the core question is always the same. Is that worker truly their own business? Are they truly in business for themselves? Or are they dependent on an employer for work? One common bit of misinformation that's sometimes out there is that it's a question of choice, that an employer can put in front of a worker a piece of paper purporting to be an independent contractor agreement, that if the worker signs it, will make that worker an independent contractor, but signing a piece of paper does not make a worker their own business. And those documents are not typically legally enforceable. What matters is the reality of the relationship and not any piece of paper. And I will pass it to Lucy.
Good morning, everyone. Again, my name is Lucy Zoe. Thank you so much for having us. So in Maryland, as is true in many other places around the country, the industries where misclassification is particularly prevalent are in construction and landscaping, caregiving, both home care and assisted living, transportation, residential and commercial cleaning, and the app-based gig economy. One common through line with all of these industries are that workers aren't necessarily regularly congregating in a single workplace, but instead are scattered at work sites, often working in isolation, and therefore don't have the same opportunity to converse with their coworkers, their colleagues, to talk about wages, talk about working conditions, and uncover potential abuses like misclassification. And as you've heard from many of the principal remarks already, many of the workers in these industries are also immigrants, non-native English speakers, women and people of color, and therefore particularly vulnerable to exploitation via misclassification.
What are the effects on Maryland workers when they are misclassified? Well, a whole large category of the social safety net applies only to employees. So when workers are misclassified, they lose out on a whole suite of social safety net protections. Things as basic as minimum wage and overtime pay, unemployment insurance when workers lose their jobs through no fault of their own, workers' compensation when workers are injured on the job, earned sick and safe leave. Advocates worked so hard to pass Maryland's Healthy Working Families Act, and when workers are misclassified, they are denied their earned rights under that law. When they're sick, when they have medical appointments, when their family has medical appointments, or when they need to take safe leave because of a domestic violence situation. Paid family and medical leave, which was just passed recently. Even just the right to organize and bargain collectively, as well as federal protections from discrimination and harassment. Employer tax contributions to Social Security and Medicare. We all get older. The fewer contributions, the less contribution that we make to Social Security means the less we have to retire on. And so this has consequences for elder poverty as well. Health insurance. Under the Affordable Care Act, employers are required to provide health insurance if they have 50 or more employees, but there are many employers misclassifying their workers as independent contractors that are not providing that critically important social safety net protection. There's a lot of very small numbers here, but what they all show is that W-2 work has greater value to workers than 1099 work. So what that means basically is that when you are an employee, more things are provided for you. The employer provides certain things. You have access to certain benefits as a result. When you are an independent contractor, you have to provide those things for yourself. Those are expenses that you have that you wouldn't otherwise have if you were properly classified as an employee. And what this chart shows, it breaks it down. This is from the Economic Policy Institute. It breaks it down by job category. And it shows, because, for example, workers' compensation insurance rates can vary based on the kind of work you're doing. It shows the different expenses that workers have based on the industry if they are misclassified versus if they are properly classified as a W-2 employee. So even though in some cases, not all, a misclassified worker, might be told, oh, well, you're getting, $18 tax-free, quote unquote, tax-free, instead of, $17 as a W-2 employee. And a worker might say, okay, well, that means more money for me. There's a whole additional category of expenses that misclassified workers have. Many of our clients, public justice center, home care workers, drivers, other low-wage workers, are surprised when they have a tax bill at the end of the year that's in the thousands of dollars instead of a tax refund. And many simply do not file taxes as a result. They do not have $6,000 waiting at the end of the year to file taxes, which leads to crushing tax debt when those years add up. This has already been alluded to, but misclassification also hurts law-abiding businesses. There's a 2015 report also from the Economic Policy Institute showing numerous state-level studies showing that between 10 and 20% of employers misclassify at least one worker as an independent contractor. And that hurts the businesses that are doing the right thing and properly classifying their workers as employees because they're forced to compete with employers that have fewer expenses and higher profit margins as a result. And that's not fair to the Maryland businesses that are doing the right thing by Maryland workers and by the law and playing by the rules that exist. And the lack of enforcement punishes good employers and creates a race to the bottom for employers that are trying to get by.
So you've heard from Dave the ways in which misclassification negatively impacts workers and also law-abiding businesses. But the repercussions don't stop there. Misclassification also hurts government revenues. And numerous studies, both at the national and the state level, have documented sort of the shortfalls that result to government revenues as a result of misclassification. Two of those studies we've included here. For example, a 2009 report by the Government Accountability Office estimated that misclassification costs federal revenues $2.72 billion in 2006. And a 2000 study commissioned by the U.S. Department of Labor found that misclassifying just 1% of workers as independent contractors resulted in annual loss of $198 million to unemployment insurance trust funds. This chart comes from the same report by the Economic Policy Institute that Dave mentioned earlier. Again, it's difficult to see the numbers here, but the upshot really is that when workers are misclassified, the full burden of social insurance payments, that is Social Security, Medicare, workers' compensation, federal and state unemployment insurance, those payments fall, on the worker alone. And the total revenue received by the social insurance system decreases. So again, difficult to see, but for example, just taking the top row for a typical construction worker, that leads to about $17,000 to almost $3,000 of a difference in social insurance payments. State studies corroborate these findings. They indicate that states lose tens of millions of dollars in revenue from income taxes, from workers' compensation premiums, and unemployment insurance taxes. So the magnitude of the problem here is incredibly significant and results in reduced funding for really critical public programs.
So what are other states doing about this really devastating issue? They're doing targeted investigations in priority industries. We saw that this problem is more prevalent in some industries than others. It doesn't affect all industries equally. And those in charge of enforcing the law are doing targeted investigations in these priority industries. And critically, oftentimes they're doing affirmative investigations. They're not waiting for people to report a violation to them. They're doing audits affirmatively. They're coordinating data sharing. We've heard about that. Very, very exciting that will be happening here in Maryland. Cross-training agency personnel across different agencies on this issue and how to spot it, and creating materials to support activities to combat it. Public outreach, also pretty critically important because there's so much misinformation about what the law provides and about what the consequences are to workers and employers when workers are misclassified. Annual reports. It's been a while since we had an annual report on this issue in Maryland, and we're excited that this task force will start the ball rolling towards getting those reports out again. Regional collaboration. The issue doesn't affect states in a vacuum. It affects workers across state lines. Very often workers in certain industries, such as construction, work across jurisdictional lines, and collaboration can be very important to combat the issue. Leveraging state contracting, putting additional terms in contracts to ensure that both the prime contractor and any subcontractors don't misclassify workers. Most of these are from a really outstanding report by the National Employment Law Project from 2020, which is just listed there. And we'd also highlight New Jersey's very strong and detailed 2019 task force report on this issue. And I'll also note a few things that our own state of Maryland is doing already on this issue. First, this task force is a really big deal. It is a really big deal to restart this and to get a renewed focus on this problem where there hasn't been one in recent years. Supporting legislation, as Governor Moore's administration is doing to address this issue, also critically important. There's a bill this year, for example, speaking of leveraging state contracting. Medicaid is a huge funder in our state, and Medicaid-funded home care is one of the worst industries for independent contractor misclassification in the state of Maryland. It has gone unaddressed for years, and this year, Governor Moore's administration is supporting legislation that would ensure that when workers are providing care that's publicly funded through a Medicaid program, those workers must be properly classified as employees. There's a guidance document that the Office of the Attorney General wrote in coordination with the Department of Labor and the Department of Health concerning this issue of misclassification, specifically as applied to home care and personal care, getting that information out in plain language that anyone can understand to every registered home care agency in the state of Maryland. Also critically important. And reporting. We talked about the need for data, and Secretary Wu mentioned the lack in some circumstances of concrete data on this issue. There is now a law requiring that, again, Medicaid-funded home care agencies report to the state how many workers they're classifying as employees and how many they're classifying as independent contractors. Again, we have special responsibility with state dollars to ensure that workers are treated correctly, that their rights are respected, and that public dollars are being used responsibly. So we will end there and just once again express our gratitude for everyone involved in this task force and very excited to see the task force and its work move forward. Thank you.
Thank you, both of you, for that presentation. I want to open it up and see if any members of the task force may have questions for our presenters at this time. Okay, great. So one of the key duties of this task force is to engage with external stakeholders, as I said earlier, to better understand how workplace fraud is impacting all of us. And also we want to understand, how we can better serve to address these concerns. So we want to hear from the regulating community. We see this as the first of many opportunities to do that. I'm grateful to our panelists for being here today. So we're going to go down and ask each of you, our experts, to give a few minutes of remarks, and then we'll ask everyone to speak first, and then we'll open it up for questions. So first, I'd like to start with President Donna Edmonds.
Good morning.
Good morning.
Oh, turn it on. I don't do mics. I don't really need it, but we'll use it here. Okay. Thank you. And I too want to express gratitude and thanks to Governor Moore and to Secretary Wu and the Comptroller and the Attorney General. This is a this is just a benchmark. This is the beginning of what we started in 2009. I want to go back to Governor Moore's remarks and the Attorney General's remarks when they are referring to this as workplace fraud. When we say misclassification, that's like, oh, you misspelled something. No, misclassification is on purpose. It is illegal. And that's why it is workplace fraud. I was there 15 years ago during the task force that wrote the first workplace fraud law. It took us months. We worked with all the stakeholders, businesses and labor and our government offices. It took us a long time to craft what we got. And it had 27 amendments to that bill. It didn't go far enough. And as usual, Maryland was first. I spent about 4 or 5 years following that, going around state to state with the AFL-CIO, helping those states that we've just heard are ahead of us in reporting and finding and enforcement, helping them craft their workplace fraud. We were the first state that called it workplace fraud. That's what it is. And so it literally strips workers of every protection, every single one. And our first, in 2009, only dealt with construction and landscaping. And as you will hear and know, it is everywhere. And it affects people of color, it affects second language, it affects women, especially our low wage. And you're in a position where you want the work, but you can't say no if somebody's putting a piece of paper in front of you. So we really have to go about educating as much as we can. I think that there is a lot that we can do. One of the things that I've done that you might not even have thought, in all of these tax credits that we give away to businesses, we were not defining what a good job is. But in the middle of that, my thought came up. Anybody who gets tax credits to create a job, they must pay UI and workers' comp. We don't have to say you can't 1099. We just say you have to pay workers' comp and UI. And that means that they are an employee. And so there are tweaks to current practices and laws that we need to look at. And, we know because we have a bill in as well as within our home care, we're still asking for stronger penalties when it comes to wage theft and construction. Obviously, what we're doing is not enough. And so we're here as a willing partner, and we will, any, resources or information or any time that you want us to participate, we are all in. I can't say thank you enough. This is so important to thousands and thousands of workers. Well, we have 3 million in the state. And this is so important to get it right now because the emerging industries are the ones where we're going to see a lot more attempts at 1099. And so we have to have it right now. Thank you very much.
Thank you, President Edwards. Let me turn it next to, Sally Moore-Fisher with the National Employment Law.
I find it weird to be using a microphone. Can people hear me?
Yes.
Okay. Again, thank you so much for having us. This is really exciting, inspiring, thrilling. As someone who met Donna working on the original Workplace Fraud Act many, many moons ago, it's exciting to be back and see this kicked off again. These very serious issues are issues which the National Employment Law Project has been focused on for many years. We're a 50-plus-year-old nonprofit national policy organization. And, I'm excited to be here on behalf of NELP as well, and just want to mainly put out there that we're happy to continue to serve as a resource to the Joint Employment Task Force, to do whatever, presentations, what have you. I know we're time limited here, and the Public Justice Center has already covered most of the main points. So in my limited time here, I think I really just want to focus on a couple of high-level best practices, takeaways. And the first and foremost, as you've heard, target the high violation industries. And you know what they are, the Public Justice Center laid them out. It's home care, it's construction, it's transportation, and increasingly, it's digital labor platforms. And I don't think Maryland has been on the forefront of the what's going on in the digital platform work, but at the National Employment Law Project, we hear about it all the time. You want to look up Quick, which is a digital labor platform that sends 1099 workers into hospitality and restaurants. They've recently been sued by the San Francisco city attorney, I believe it was, and got a multi-million-dollar judgment against Quick. Those digital labor platforms are increasingly operating in Maryland. You need to keep an eye on those. Second, enforcement has to carry meaningful penalties. It can't just be a slap on the wrist. So if you're gonna have a penalty, the penalty needs to be significant enough to change behavior. And enforcement can be, these penalties can be more than just monetary penalties. You can look at New Jersey, and in the wake of their 2019 report, they went about changing a number of laws. Now they have something called the Workplace Accountability in Labor List. And that's called the Wall of Shame in New Jersey. You can look up on the Wall of Shame what businesses have been violating the laws, what laws they've been violating. And that's noticed to everybody. Good businesses know, workers know. It's a beautiful thing, and according to New Jersey, it's been making a difference. Number 3, up the chain liability. You can't play whack-a-mole going after every next LLC. You need responsibility from the top. So businesses that are turning a blind eye to the practices or profiting off like super low wage workers, those businesses need to be held to account. I know in a number of years ago, there was a law passed to create up the chain liability for construction contractors in Maryland. That shouldn't be the case just for construction contractors. You know, in many of these child labor cases that, you know, there's been this incredible uptick in child labor. They're getting away with it in part because the you know, Frito-Lay and Cheerios and Fruit of the Loom are not held to account. It's like the subcontractor sending temp labor in the form of child labor. So up the chain liability is another crucial component. And finally, collaboration and outreach. You know, I'm so glad to see the information sharing among the agencies. That's going to be terrific and go a long way. There also needs to be a lot more information and outreach sharing, collaboration with worker centers, unions, even good businesses. These are the folks that know what's going on the ground and can give you the tips on where to go to enforce. I did just want to point out also, I'm not from New Jersey, but I feel like I'm touting them a lot today. New Jersey also entered into an MOU with Pennsylvania, our neighbor in Pennsylvania. And the governors of New Jersey and Pennsylvania have said that they're interested in entering into MOUs with governors in surrounding states. So to the extent that you didn't know about that, you know, Maryland might want to consider this joint regional collaboration on workplace fraud as well. And then finally, in all your work, you know, keep track of where the law needs to be changed because, you know, issuing this report can be a great launching pad to really strengthening the law where it needs to be strengthened. So that's my story. I'm sticking to it.
Thank you. Let me turn it to Greg Ackerman, President of Building.
Thank you, Chair, and to all who've convened this conversation. And you know, I'm honored to go after Donna and Sally. You know, you all did really great work. I'm with the building trades unions, who are council of all the 28 construction trade unions in the region. Misclassification is rampant in our industry. We see it on most jobs in the region. It's important to point out that it didn't start that way. You know, it was initially just in the residential sector. And you know, we're at fault for, you know, kind of ignoring it just because it was in the residential sector. But we've seen it, you know, rampant in the commercial sector. It's on several of our public works projects in Maryland. And it's only now increasing in trades, licensed trades, where we previously hadn't seen it before, you know, with you know, electrical work, plumbing. And so, you know, despite all the bevy of really strong laws that have been passed in the state, we've actually only seen the issue get worse for a number of reasons. And so, you know, it's important for us to really emphasize, you know, the numbers are real, and we actually, you know, we believe they only really scratch the surface just because so many workers are not willing to come forward, largely in part because of their immigration status and because, you know, contractors do not hesitate to retaliate and threaten vulnerable workers. You know, a lot has been said about enforcement. Enforcement is really, really important. Prevention is also incredibly important, and in my opinion goes much farther than enforcement. Prevention doesn't just mean education. You know, a lot of the times contractors that we talk to, you know, they're aware that this is an issue, and because of the business model, many legitimate contractors have gone out of business, you know, union and non-union, because of just how prolific this issue is. And so, you know, prevention in the form of debarment is so important. You know, we're aware of contractors that have been, you know, sued, paid hundreds of thousands of dollars in fines and penalties for violations on projects that were funded with Maryland taxpayer dollars on our public schools that are continuing to work on other publicly funded projects. And so being able to collaborate, you know, with the task force to ensure that the bad actors are getting punished, that you're actually capturing who the bad actors are, is so important, because that's a really, really important element of prevention that I believe that we're not really, you know, utilizing to the full extent. And then, you know, just I think colleagues captured a lot of really important points, but I do want to point out that, you know, it's really important that everybody who's at the table is you know, is here today. But, whatever we can do to empower the folks that are at the table, we really want to, I really believe that everybody here should be empowered to, to fulfill the mission of the task force. And that, the thing that the Biden administration is doing that is so important is empowering the Department of Labor to work with other agencies, to work with procurement, to leverage, the power of the federal dollar and federal procurement in order to, not just prevent misclassification, but to affect private sector behavior. And so it's going to be really, really important that not only folks that are here at the table, but that also we're looping in, DGS, the procurement agencies, our universities, economic development to ensure that, when we are spending taxpayer dollars, that this task force has oversight over the business practices. And finally, I just do want to speak from experience that, we've seen some pretty significant enforcement measures over the last several years. They have made a dent in the market. It does make a difference. It is important to point out, though, I think that the biggest settlement that I've seen, is in and around the $3 million range against a well-known, bad actor in the electrical industry, has really not made a dent in that particular contractor's business practices. In fact, Power Design, this contractor is well known in the region. They continue to do work in the commercial sector. They're actually not just in electrical now, they're getting into plumbing and mechanical. And so, we really need to look at all avenues. Just having, a couple press releases and some big cases and, settlements is really only going to scratch the surface of misclassification as long as it remains a profitable business model for bad actors. So appreciate the opportunity to provide some comments to the panel, and we're willing to, again, be a resource at any time.
Thank you. I'd like to hear from Ms. April Sims.
Good morning, everyone. My name is April Sims. And I'm a certified nursing assistant and a geriatric nursing assistant. I've been a home healthcare worker for 40 years. Caring for people is my higher calling. Unfortunately, home care workers face many challenges. We're not a union member, and many of us are misclassified as independent contractors. So home health workers have the lowest pay, worst benefits compared to all other healthcare workers. I was misclassified as an independent contractor. Since I was not an employee, I wasn't reimbursed for my mileage, even though I was required to use my vehicle. I didn't have protection like workers' comp, minimum wage. I had to have a tax burden every year. Worst of all, I had to buy PPE. You had to purchase your own PPE. It's expensive to be misclassified. After paying for mileage, bag taxes, and supplies, there was almost nothing left over in my check. It was so bad that I quit my job. I had to find another job. Maryland needs to prioritize the healthcare workers so that our elderly and those with disabilities have support and care they need to live. This year, 2 important pieces of legislation are moving forward in the General Assembly that will bolster job quality for home care workers, and this is just the beginning of creating the future care well deserved. The Home Health Care Workers' Rights Act could help end the misclassification of home care workers by ensuring that the Department of Health only provides Medicaid reimbursement to agencies whose workers are W-2s. If these agencies want our hard-earned public dollars, they better be treating workers right. The Home Care Workers Employment Act will make sure that the Department of Labor is collecting basic information on our wages so that we can take care of necessary steps to increase wages in the years to come. These bills benefit our clients as much as it benefits us. High work turnover in home care because of low wages and worker misclassification is stressful for our clients. To them, it feels like every time they start to get comfortable with someone that they know, they quitting on them. They deserve consistent care. Maryland has no potential to build a stronger care infrastructure. We can create direct care workforce boards where workers' voices are centered in improving job quality. We have platforms that connects people needing services to healthcare workers that can meet their needs and that gives workers opportunities to get the training they need to help those with various disabilities. We can have adequate provider rates and wage floors for our home care workers that will ensure living wages for all. We can have greater collaboration between Department of Health, Aging, and Labor to support the care workers. I know we can do it, and I hope we will join the care revolution with me.
Ms. Trisha Baldwin.
Sorry, give this up if I can put it back in.
That's all right. Good morning. Thank you. My name is Patricia Baldwin. I'm with a Reliable Contracting Company. We're a contractor we've been in existence almost 100 years now. We have now about 500 employees. We deal in the classification several ways. The non-exempt versus exempt, the prevailing wage, we struggle with that, getting the right classifications, getting the correct rates, and navigating the paperwork that involves. And we also rely a great deal, because of the nature of our business and the inability to hire truck drivers of our own, on independent contractors that own. Sometimes they're often small contractors that have one truck and they're driving it and that's what they want to do. Or they have a few trucks, and we rely a great deal on them in the summertime because we do not have enough truck drivers to deliver our material or serve our construction sites and construction projects. I'm a member of the Associated Builders and Contractors and was asked by them to be here to represent our members. I want to thank them because they are instrumental in helping us navigate all these employment laws, the federal government laws, the state laws, and even some in the counties differ as well. So we really appreciate them, and we've been a member with them since they began, the ABC Chesapeake chapter. And thank you for including us.
And next, I think we're headed for Mr. Allison. Yes, you do.
Thank you. My name is A.J. Claymore. Alexander's my dad. I came prepared to speak about some of the more technical aspects of ABC and that kind of stuff, but I think the folks from the Center for Public Justice have done a better job of that than I could. So if you'll permit me, I'm going to get a little personal here. UFCW is United Food and Commercial Workers, and we represent 1.2 million workers throughout the entire country. Here in Maryland, we represent about 30 to 40,000 employees who work in grocery stores mostly. How many of you guys have used Peapod in the recent days? Anybody? Get your groceries delivered? Those are union workers. If you go to a Giant or a Safeway in the area, those are our workers. I say that in part because UFCW isn't just, I work for the International, I cover states east of Mississippi for the most part. But UFCW in Maryland is personal for me because my grandfather was a shop steward in UFCW Local 400 for 30 years. Shout out to Local 400. My grandfather, he is a deacon at First Baptist Church of Glenarden. He bought his house with his unionized wages back in PG County on Ardmore Road, where he still lives to this day. In many ways, he's a member of his community, serves as a mentor and a servant in his church and in his community. He's been able to do that because of the pension that he survives on from his unionized job. Now, why am I telling you guys all this? You guys don't need to hear about some old man who's running around his neighborhood helping clean the streets. Well, the reason I'm telling you this is because I want to give you a sense of some of the implications for what happens when employee misclassification is not prosecuted vigorously. And I think the most stark example of this for us had occurred out in California a couple of years ago, where we were engaged in a union campaign to unionize the Safeway delivery drivers out there in San Francisco. Now, we were successful in one part of that campaign. 150 workers were able to become unionized. But shortly after we signed our agreement, I think it was Prop 22, out in California, passed, which allowed delivery, TNC companies like Uber, Lyft, and Instacart to misclassify their workers. Safeway signed an agreement with them and laid off the rest of their non-union workers. They laid off their non-union delivery drivers so that they could partner with Instacart. And the reason I told you that story about myself, about my family, is because it makes me wonder every time I think about that, how many pillars of communities did we remove when that happened? Every time one of those hundreds of workers is laid off and are forced to pick some other new job that doesn't pay as well, doesn't provide the benefits that a union job does, we're removing pillars of communities. And I've got my brother from the building trades here. He can tell y'all what pillars do. They hold things up. And so that's my story. Shout out to Wayne Claiborne. That's the implications of what it means when we don't enforce our laws and aren't going after these companies for misclassifying their workers. So I thank you guys for allowing us the opportunity to speak, and I look forward to cooperating with you guys in the future.
Thanks very much, everyone, all the panelists for their comments. I want to open it up and see if some of the task force members might have questions for some of our experts. Commissioner Dodd.
So this one's for Greg. I've got the account reports for our area, being the Commissioner of OMP. What do you see as really strong deterrents to really stop the practices you were talking about?
Thank you for that question. Y'all are more experts on me and the ins and outs, but I think that the key is that, this may have already been covered, but there's so many different types of violations that occur when you are misclassifying a worker, right? There's unpaid unemployment insurance, workers' comp premiums. Oftentimes in the construction industry, that's paired with unpaid overtime, right? So just straight wage and hour violations. And so, just looking at the totality of violations that occur on a job and coordinating amongst the different, the different agencies, so that if there are violations that are already, grounds for the loss of a business license or, whatever other kind of damages and relief that the various different boards have existing statutory authority to enforce, that information is getting shared so that we're you have the opportunity to actually look at the case as a whole. Oftentimes we're aware that the loss of a business license or even getting debarred from public or private work, right, in fact, is an option that's on the table. It hasn't been exercised, and so we rely on the experts, and would love to maybe get some more details about how we can then leverage the fact that several mechanical contractors have to come from the board and renew various licenses or get various approvals. But we would love to look at options, whether they're existing in law or whether we have to get additional legislative approval for expanding authorities across different agencies.
I have a question, and President Edwards, you alluded to this. Maryland's previous work was fraud statute, the focus, and you and many people in the room worked on that. The focus has been on construction landscaping. What do you think are the implications? But we heard a lot about how this issue is arising in a lot of industries. What do you think are the implications of having a statute that's only focused in some areas? And do you have thoughts about whether policy should be different?
Yeah, we're a team. Just so you know. Okay, we haven't practiced our course yet, but, and you got me right when I have a sore throat, so I put a piece of candy in there. I think that our workplace fraud that we passed was weak. And going back to what Greg said, there are things, we have several tools in the toolbox that we've never used. We never use disbarment. We don't, publish a list of who the bad actors are or what has happened. This is the first time that we're beginning the coordination among all three, Department of Labor, the Comptroller, and the Attorney General's office. So we never put in any of the guidelines that could do the enforcement. We lack the ability still, we are understaffed, we know that, in enforcement in all of your areas, in all three key. So we haven't staffed up so that we really could tell the industries, and it's across all industries, and it's going to be in the emerging industries as well. So they know that we're understaffed, they know that you don't have teeth yet, they know that they get a slap on the wrist, and probably also just put this into their business plan. I could lose X amount of $1 million if I get caught, but if I don't get caught, then I can take that forward and it's less of a penalty as I go forward.
Yeah, I would agree with that. I think it sends a message that other industries, it's not as important in other industries. And, you know, frankly, when I was in practice in Maryland, you know, at the Public Justice Center, we have people come forward, and the Workplace Fraud Act has the ABC test, which is the strongest test that there is. And I think that's the way to go, is to presume, most people, you know, let's be honest, most individuals are not, when they're working, they're not running their own businesses. Most individuals are employees of someone else. They're not running an independent business, they're dependent on working in the business of another. So, you know, the ABC test has that presumption. Employers can overcome that presumption. They do overcome the presumption. Massachusetts has an ABC test. Employers can overcome the presumption because they have most of the information. I think that particular approach to who is an employee and who's an independent contractor is really the strongest approach, and it mirrors the reality that most workers are employees and not independent contractors. And I think that limiting it, you know, look, every bill is kind of a compromise, right? You start with two industries, and the understanding was you start with those two industries, and then you see where else it is. And you know what? By now, it's all over. And there's no reason to have to just the landscaping and construction, particularly when now landscaping, you know, in Maryland, landscaping is like, Maryland is like the 5th highest recipient, I believe, of H-2B workers. It's not necessarily an independent contractor problem anymore, it's a guest labor problem. So like, it's a little bit anachronistic at this point to just limit it to those two industries. And particularly, again, you know, as I noted with the growth of app-based digital labor platforms, those are rife with independent contractor misclassification. And, you know, this is a little bit out of this realm, but those app-based digital labor platforms are forming well-financed coalitions to go around and rewrite the laws so that they can legalize their misclassification. So it's coming to Maryland. You know, I think we want to get a jump start on it and start looking at, and those industries really need to be, you know, regulated.
Yeah.
Oh,
Could I?
yeah, sure. Go ahead.
Sally just reminded me of something. One of the things that I would urge you not to do, or to do, but do not tinker with what we already have. Use that as our strong construction-based foundation. We spent a lot of time on making sure that the ABC test remained in the workplace fraud bill. And I don't think we should go back and look at what was wrong with that, use it as the jump start and not tinkering, and then what do we make it stronger? How do we do that?
And I will get back, sorry. I was just reminded of something that was brought up earlier, is that, yes, there are different tests because different laws have different functions, right? So what is the function of these workplace laws? It's to provide broad coverage. So we need an ABC test. And it's also, frankly, nothing new, nothing anybody should be surprised at. Maryland has had the ABC test in its unemployment insurance law for decades. So if you can comply with that, you can comply with it in other contexts. And the simplest way to avoid having to apply with all these different laws is to just comply with the ABC test.
Yeah, I was just going to add, speak to the piece about the big coalitions that the TNCs, the Ubers and the Lyfts have put together. UFCW is involved with the Massachusetts AFL-CIO right now in a big campaign to have the ABC law enforced in Massachusetts, which in Massachusetts has been in place for decades, but they weren't enforcing it against Uber and Lyft and such. And the Attorney General there, well, now she's the Governor, Maura Healey, brought a suit to enforce it. And this triggered a huge campaign from those TNC companies to try and get the laws changed to allow them to cheat, basically. When Sally says it is coming to Maryland, I promise you it's coming here. We've got to be willing and ready to enforce and apply the law across the board evenly to make sure that these companies whose business models are basically just for them to cheat aren't able to drag us down to a race to the bottom.
I'm going to direct my point to everyone, but maybe Ms. Baldwin, you're in the most unique position to answer to this. Before I became chair, I spent 20 years on the bench hearing the cases of injured workers whose employers were claiming that they were independent contractors. And while that defense oftentimes failed, what I've come to conclude is that we really need better insurance models if we're really going to conquer this problem. And specifically in the construction industry, where you might have, 5 guys that you can keep employed year round, but then you get the big jobs in the door. And what you really need is 8 more workers for 6 weeks. There aren't insurance companies that want to give you that policy. And that's one of the reasons that small construction companies cheat, because they can't call up their broker or get on an app and say, hey, I need a policy for 6 weeks for 8 people. And what I'd like to see us do is think about that, because the goal really ultimately isn't just to find people into bankruptcy, it's to get them into compliance.
Yes, thank you. I'm not a lawyer, not an expert. My understanding, and when we hire independents, we require insurance. And my understanding from our own insurance company is we're often responsible for an independent driver and their misdeeds or their mishaps and things like that. So I find that we're responsible in a lot of ways anyway, and so it's hard for us to make sure we've got people that are licensed to drive the trucks that they're driving, having the insurance so that if they do get injured, it's a difficult thing to police, I guess is the word. We can't know what they're doing, and other than I get the certificate of insurance, I get now verified licenses to make sure they're qualified to drive the dump trucks. It's almost always dump trucks that we deal with. So I don't know if that answers your question or not.
If I can just address that, I don't know the ins and outs of how our existing signatory contractors, we have hundreds of signatory contractors we work with that comply with that model. And, I think the really important point is that, an alternative to not being able to find a workers' comp policy should not be breaking the law, right?
That's right, yes.
Because there are contractors that already do that, and I'm sure there's many more complicated aspects of running a business that business roundtables address. And if we need to look at our solutions in order to make that part a little bit easier, then we encourage that. But you have this race to the bottom that we see not just with workers' comp, but with all the other issues related to misclassification. And it's really important for us just to make sure that we're level setting, that compliance with existing laws has to happen regardless of whether workers might sometimes want to claim they want to be independent contractors or any other factor that we have. And we've got a broken immigration system with thousands of workers who are in the shadows that don't have the ability to come forward or are scared of coming forward. That really we have to make sure that we're providing all the options for these people to come in compliance with all the relevant laws.
If I can just jump in very briefly with one additional point, I think such an interesting observation, and it just makes me think about how there are certain sector-specific issues that might be contributing to independent contractor misclassification, and that the implication of that is that there's not necessarily going to be one easy, one quick fix to workplace fraud, and that a really focused and intentional approach requires delving into the details of specific industries and the particular push and pull factors in those industries that might be contributing to misclassification, and working on the big picture things like expanding the Workplace Fraud Act to cover more or all work, as workplace fraud exists in all work. But there might also be industry-specific solutions like getting into the weeds of workers' compensation insurance protections, or like in the home care context, specific things that concern home care, and that the comprehensive approach that I think this task force provides is an avenue to dive into those very specific issues and propose solutions as to how to address them.
So this has been very interesting, and I think I have more sort of long-term questions, and I feel like both on this task force and individually, I kind of want to partner at some point with each and every one of you, because I see a touch point for the insurance administration in all of those areas. You know, we, from a consumer education and advocacy standpoint, you know, we do over 500 in-person events here. We're everywhere all the time, from big stuff at the fairgrounds to literally somebody's barber shop, because we want to meet people where they are as they are. And we work really hard to build trust in communities, right? And particularly communities that have been underserved, and we work with consumer advocates in those communities to create those trusted relationships. So we are a great place for the part that's education to be able to help workers be aware of, you know, their concerns, and maybe partner with our fellow agents to bring you onto the ground with us as we're having those interactions. But when you're talking about that digital platform, right? So I'm very interested in talking a little bit more about that and learning more, because many times those digital platforms have an insurance component attached to them, because what will happen is that you're inviting the independent contractor worker to find work that way, right? But there may be how do wages get, so who's doing the back office work of collecting the independent wages, and then they're selling an accident occupational policy because the worker isn't entitled to workers' compensation. And then how is that getting marketed? So as you know, indicia, badges of fraud. What are the indicia's badges of fraud? I don't regulate the workplace, hourly wage, et cetera, laws, but what I can do is I can look at what those arrangements are underneath and see if there is insurance fraud that's happening, or unlicensed people have illegal arrangements for their compensation, because I guarantee, in many of those cases, that platform entity is getting a cut of that insurance premium and those amounts that are coming out of now, whatever the amount of money that might be coming through that platform because of a worker that's working in lots of different areas. So I want to explore what you're seeing, because that's an area we can help. With regard to the trades, right, you talked about the fact that when you hire an independent, you are responsible and you want to make sure that they have insurance. So you're going to get their CGL coverage, certificate of insurance. You're going to do that for workers' comp as well, right? If you call the carrier, if you call the broker, so I have my associate commissioner of fraud here, because one of the biggest areas that we see is that companies that are small and they're not paying, they're struggling to pay workers. What's one of the things they let go? Their insurance. But they repeat that certificate of insurance, they go in and they alter it, right? And so we deal with those cases all the time. But the folks that are doing that, those are the folks you need to know about, because they're probably already, so, you know, there's not just one fraud of one type happening. So I feel like there's so much that you've identified where, you know, the insurance administration might have one little slice of what that is. We can be an advocate, we can promote education, we can look at the underlying things. But through that avenue, we may be able to then do that entry point where we can work with our fellow agencies to say, well, what's the bigger picture here? So very inspired by what you've said, and really anxious to start to work more concretely with you guys.
Well, and Commissioner, thank you. I think your remarks are a perfect example of why we want to bring everyone together, because some of us have been working on this issue a long time. I think we know a lot about it, but then there's just another dimension that you bring to it and say, okay, that's another place where we can have information and bring it into this broader mix. So with that, first of all, I want to thank our panelists. I'd like to transition to some more conversation, and I know obviously this opening meeting is to spark some of these ideas flying, identify some potential areas of work. There is a lot to do, And so part of what I think we'd like to do is now transition to a discussion among the agencies to have a sense of, what are the resources and data you have? What are you bringing to bear as the commissioner started us on this conversation? And also looking at, counterparts around the table saying, what do I need from you? Or maybe this is a potential touch point or opportunity for greater engagement. I know I've had the pleasure of having some conversations with the Attorney General on this point, but Mr. Attorney General, I don't know if you wanted to lead us off with saying a little bit about the resources and focus of your office and also where you see potential for some engagement with some of us.
I thank you, Madam Chair. Again, I think it really, the reason why I'm very excited about this task force is I think we can sort of, remove some of the silos and the barriers, the walls between agencies and collaborate and work together. In the 2009 timeframe, when Maryland looked at, and enacted first in the nation statutory provisions to protect workers against workplace fraud. What probably didn't happen so well back then was a strong partnership between the OAG and DOL. And so referrals and enforcement kind of lagged. We had great laws on the books. We really didn't step up enforcement. And then we went into the last 8 years where, the relationship, just did not exist, and we didn't have a governor who was committed to this work. So as we're looking at what laws we do have on the books, and they can be strengthened and improved, my focus is really on enforcing the existing laws that we have. Because I think that is important when eventually we go to the legislature and say we need stronger laws. The legislature is going to ask, well, what are you doing with the current laws? And if the answer is, well, we're not really doing that much because we only have misdemeanor penalties and we need felony penalties, or higher monetary penalties, like, well, you got to show us how your existing enforcement is not getting the results you want. We can't do that now because we're just not enforcing at the level that we should. I know that there's an effort to ramp up the number of investigators. We need to do that. As I mentioned, I'm bringing up more attorneys to do the work. And this Tiger team that I mentioned, it's going to be designed and working with the secretary, working with everyone around the table to be able to, in a very nimble way, kind of move between the department, my various divisions, because even within the Office of the Attorney General, we're somewhat siloed as well. So we have to look at the existing authorities, resource our agencies, better coordination, and then we can not only make a little bit of progress in that area, but be able to then make the case for more resources and better authorities.
Sure, yeah, no, I'm really excited about this, and it was so great to hear from all of you, your different perspectives, and of course, coalesce into some really important facts about what we need to be doing and why it matters, and recommendations, so thank you. I also want to talk about making sure that our agency is able to do this work robustly. As I mentioned earlier, we have a number of different divisions within the Office of the Comptroller, and within the Office of Revenue Operations and Accounting, we have a division called the Compliance Division. That Compliance Division is our auditing team. We have business and individual field audits, business tax audits, and more. And we recently did some work to look into our compliance team versus other compliance departments around the country. And we discovered that we have one of the smallest compliance teams in the nation. So we have 272 PINs in our compliance division. To give you an idea, New Jersey came up a lot. They have 750. So this is also a matter of ensuring that we have the resources and the team members to do the investigations that need to be done. So I'm really grateful to the Secretary of Budget and Management and the Governor for helping us secure some additional PINs for our compliance division this year. And we want to keep building on from there, because this work is intensive. There's a lot of paper involved as we move from State Center to our new office in 7 St. Paul Street. I've seen the boxes and so many bankers' boxes of paper that we're digitizing now. I'm very glad to be moving past paper. But we need to make sure that we are both able to do that field audit work, take the leads that are being generated from you all and from our fellow agencies, and then go in, have the bandwidth to do the work that needs to be done to produce the results. And, you know, our tax system in America is one of voluntary compliance, right? And so the reason that enforcement is important is to make sure that those who are compliant are not disadvantaged, right? And to make sure that it's worth their while to comply, right? We have to make sure that the costs of non-compliance, outweigh the costs of compliance. So it's just, we want to make sure that we are being respectful but robust in our compliance work, working with businesses to make sure that they know what to do as well. I think this is something that comes up a lot when we talk about closing the tax gap in Maryland, is also doing the outreach and education to our partners in business so that they know what they need to do and how they need to pay. And then when they don't do it, they know that we're going to be there to follow up. So we're excited to work with all of the agencies. You know, one of the things that we'll be looking at is making sure that we can legally comply with data sharing arrangements. Sometimes talk about how we report to a higher power, the IRS. So it's really essential that we have the legal framework that allows us to do the data sharing that we can do in a confidential and safe way, so that we can maintain our compliance with the IRS. By maintaining all our compliance with the IRS, we are able to have data sharing agreements with the IRS, which bring in over $400 million a year in compliance activities. So it's just essential that we always remain in compliance with them. So we'll be excited to our legal team, work with all of your legal teams to make sure that those data sharing agreements are in place. Thank you.
Thank you, Madam Comptroller. That's a perfect segue, because I actually wanted to talk more about the data and resources. The resources we have to investigate, but sort of we can't do any of that if we don't have the data and information to understand how we should be directing our attention. I want to say a couple things on behalf of the Department of Labor, but I want to open it up first to see if SDAT or any of the commissions want to say anything further on this point of information sharing, data and resources. You know, what are you focused on in your agency, and where are you looking to us to reach out to partner?
Sure, I guess I'll start. I'm Jonathan from the Department of Assessments and Taxation. I like to call SDATs the state's filing cabinet of business registrations and business documents. You want us to put it in our filing cabinet? We'll put it in our filing cabinet. All of our data is available to anyone who needs it, and the vast majority of the data that our department has is public record and on our website for each business. So, thank you.
The microphone is made its way to the system.
I'm Jonathan from the Department of Assessments.
I know, it's everybody else, okay.
We'd like your data. The reason we'd like your data, because there is a whole group of actors who aren't necessarily bad actors, they're kind of confused actors. When you form an LLC, people don't often realize that our workers' comp law requires you to file a form exempting yourself from workers' comp. If you don't do that, you are out of compliance. And so it's very important that we help the confused come into compliance. And so you do a lot with the formation of LLCs and the people who are at your office, and we'd like to work with you to make sure that people know right away when they form their company that they need to come to us and get workers' comp insurance.
And one of the other things that we always encourage anyone in the state to do is, if you are doing business with anybody, pretty much all businesses are required to register with SDAT. There are always a couple of exceptions, but we encourage everyone to look for that good standing certificate that a business can download from our website, or you can look up on our website to see if that business is in good standing. We partner with lots of other state agencies, including the comptroller, all the time to pull businesses out of good standing until they make a correction. And the more and more state agencies and the more people that request this certificate of good standing sort of makes that certificate of good standing worth more. Banks are really good about doing it. You can't open a credit card, you can't open all these things, but if
Can't get a BPW contract.
can't get a BPW contract. But if other state agencies issue grants and things without requiring a certificate of good standing, SDAC has no actual enforcement powers, unlike the comptroller. We can't come out there. We have no SDAC police. We're just the guys with the filing cabinet. So yeah, but again, all of our data is available. So.
Can I just ask a quick question?
Sure.
Is it still the case that you can set up an LLC and, I've been on SDOT many times and often the LLC is just a PO box. So you still can't find out who's behind the LLC.
So an LLC has to have, there's a couple different addresses that we collect. So we collect a mailing address, which could be a PO box. We also have a resident agent and principal office.
Okay.
And in Maryland, we have some of the strongest laws for resident agent and principal office address. Many other states will allow you to use a virtual mailbox, UPS or a FedEx store. Maryland, we don't allow that. It actually must be a physical place, and there have been quite a few bills to change that, and the department has fought those because we think this is an important consumer protection tool, that when you're looking to serve someone for business, that there is a physical place that you can actually go to.
So I am going to do just a quick 2-minute on behalf of the Department of Labor, because we have many colleagues sitting at the table, Occupational and Professional Licensing, Jack Dove, Ed Brexis from Unemployment Insurance, and Commissioner Deputy Burke. I've also been informed that there is a hard stop in a few minutes because the tech has to flip this room. So, but I do want to say at the department, we have a number of sources of information. Obviously, labor and industry, Commissioner Burke has a lot of enforcement powers and authorities, collects information on prevailing wage and hour minute areas. Unemployment insurance, we receive wage data from all employers who are filing on behalf of employees, but therein lies the rub, right? Like if you don't think you need to be filing UI, we aren't getting your information. But I think this is where there's a critical crossover. If you're registering somewhere else as a business or doing something else, or maybe not filing that certificate about workers' comp, I'm not sure we all have the best information about what our sister agencies are getting or not, and frankly, it could help all of our work to understand like who's registering with each of us. And then of course, occupational and professional licensing, we've got over 250,000 folks who are filing for different kinds of professional licenses with us. And that's not saying that of course there's Department of Health and other licenses there too. So there is, I think, a wealth of information and opportunity here. I apologize, I'm cutting our discussion a little bit short, but that was because we had so many questions and so much interesting information from our external stakeholders. I thought it was worth hearing more of that conversation. I do want to say for next steps, first of all, thank you. There will be additional staff work. Of course, this body is subject to the Open Meetings Act, which is why we have certain procedures we have to comply with and follow. It's why we have public participation and public invitations. But of course, there's the ability for staff to do work in between our formal meetings. And I think there's a lot to explore here. And so I would ask the task force members, if there were things that were particularly interesting or important to you that you want to make sure we follow up on, please reach out to us. And we'll put kind of pose some questions in terms of area of interest. And so I will say for next steps, the next meeting, I believe, is on April 11th at 9 a.m.
Coordinating of schedules, but that is what we have.
So we will work to coordinate our schedules. We would like to continue this discussion about resources and data and get to some additional steps. How can we formalize some of this collaboration and create more integrated processes? With that, yes.
Just a formal, staffing note. The binders that you see in here, in front of you, the red binders, the cupcake and the cups are for you. The white binders are to stay where they are. They will be available to you at every single meeting per the Joint Enforcement Task Force. They will be replenished, refiled, and newly like a newborn baby, each time you sit in front of it. So we just ask that you leave your name plate and your binder on your desk before you adjourn, after you adjourn.
One question, in terms of the content of the binder, I mean, if you've written in the margins, whatever, we can take that.
Yes, any private notes, thank you, Attorney General, any private notes or things that you have, feel free to take that out before you go. But the binders and the tabs, we ask that you just keep that. So we just want to make sure that as we have documents come in, reference material, that I know that the spirit often moves the Attorney General and the Secretary to uplift the binders. We just want the spirit to stay here with the binder. Thank you all so
Preserving
much.
resources, preserving resources, we agree task force.
I'm gonna turn it back over to, because we don't have a budget, so I'm gonna turn it back over to the chair. I just wanted to make that note.
All right, with that, I need a motion to adjourn.
Motion to adjourn.
I need a second. Second. Everyone in favor? Aye. Thank you.
Actually, you got it was, the chair of,